Hello and welcome to the Big Picture. Even as the government and the Supreme Court is involved in an intense and sometimes unpleasant engagement over what should be the nature of memorandum of procedure for appointment of and transfers of judges, internal problems have cropped up within the Supreme Court Collegium. Justice J. Chalameshwar, one of the members of the 5-member Collegium, has raised several questions about the functioning of the Collegium. In a letter to the Chief Justice of India, Justice Chalameshwar has made out a strong case for more transparency in its functioning. He has also refused to attend any of the Collegium meetings henceforth and has demanded that the recommendations by other 4 judges be sent to him by circulation. He has pointed out that so far there is no record of the meetings of the Collegium and no minutes have been maintained, which he wants to be changed in the interest of transparency in the appointments and transfers. So what does this unprecedented situation mean to the Collegium system and the judiciary as a whole? Will this lead to more transparency, and how should the government react to it? We will discuss all this today with Justice B.A. Khan, retired Chief Justice of the Jammu and Kashmir High Court on phone line from Srinagar, Prashant Bhushan, advocate in the Supreme Court, Dr.C.Rajkumar, Vice Chancellor O.P. Jindal Global University, Sanjay Hegde, Senior Advocate Supreme Court, and Satya Prakash, Legal Editor, Hindustan Times. Welcome to all of you. Justice Khan, how do you look at this development? You know, the Justice Chalameshwar coming out in the open. You think, this is something which will add to the process for transparency in the appointments?
Girish, I salute Justice Chalameshwar. In fact, for his bold and courageous act of not participating in the Collegium meeting and standing by his judgment which he had given in the National Judicial Appointment Commission case. If you have a look at the judgment, you will find that he has highlighted 2, 3, 5 things in that judgment, and transparency being the foremost important thing which he has said is a vital factor in constitutional governance and is an aspect of rationality. And in the same thing, he has said that the proceedings of the Collegium are absolutely opaque and clannish. He has been here, in fact, his critique in this judgment, if you go through, exposes the working of the Collegium and the process of the appointment of the judges to the higher judiciary. Now, can you imagine a Collegium meeting not recording a reason for rejecting a candidate? Or can you imagine a meeting which we in the courts sometimes set aside or quash for not giving reasons for such rejection, or not for recording the minutes of the meeting? Now, such kinds of selection which are being made, and if Justice Chalameshwar raises his objection to it today, he will encourage again a fight for ensuring transparency in the judicial process.
Okay. Okay, sir, I'll come back to you. Prashant, how is it that, so far this procedure of the Collegium has been going on for so many years now? This issue has never come out in the open. This issue has not been discussed before. That these kind of the whole proceedings of the Collegium is not recorded. Nobody knows what happened. How is it that it has continued like this for so long?
Well, we have been raising it from our campaign for judicial accountability. We have been saying that there needs to be a clearer criteria, or at least a laid down criteria for selection of judges. There needs to be a method for evaluating the various candidates on that criteria. And there needs to be at least some transparency in the whole process of appointment, at least to the extent that names of the proposed candidates are put up on a public website. Members of the public can also send whatever information that they have about it or not. Besides this, as to which members of the Collegium said what about these appointments. This should also be recorded and made known under RTI. In fact, we had filed this RTI application on which the Central Information Commission ordered them to provide information about the minutes or whatever communications have been made by various judges regarding selection of judges. But unfortunately, that has been stayed by the Supreme Court, and that issue has also been referred to a constitution bench. Now, we have been raising it, but it is the first time that a member of the collegium, a judge who is a member of the collegium, has raised it and raised it publicly. It's possible that members of the collegium have raised it earlier within the collegium, but they have not raised it publicly. Justice Chalmeshwar has raised it publicly. That is why people have come to know that the issue of transparency in the functioning of the collegium in selecting judges, that this is a issue which has been raised.
Okay. Okay. Dr. Rajkumar, you think it is the right thing that Justice Chalmeshwar has done? Because there are people who are still, who are very uncomfortable with the fact that he has raised it publicly. Some people even feel that it should have been done within the thing, not to come out publicly.
Well,
he himself seems to have had some hesitation earlier.
Well, so to begin with, I think it's important that after all what he has told in the form of this letter and his views are pretty much reflected in the judgment. So it's not something which...
in his judgment in the NJAC case.
Yeah, absolutely. Those are his very well thought out and informed views. It's another matter that an institution like the judiciary and individual judges, if they were to reflect their views and perspectives in public domain the way he has done, I'm not so sure how much it will strengthen the institution itself. Because at the heart of it, the main problem that we are going to see in this whole situation is that I believe that the judiciary ought to have handled this matter in a much more responsible manner. It should have, I think there is a question of institutional leadership which would have been, which would have involved the members of the collegium discussing in a more threadbare manner. Only I think he is best suited to tell, and probably he has, which is that, in some ways it has become probably for him, I suppose, impossible to anymore be part of the collegium discussions, and hence he has come out of it and says that he will look at the papers. But having said that, I have no doubt about the fact that all of this doesn't augur well for strengthening the institution itself. I think we have a big crisis now, both in terms of the very appointment process, but also the legitimacy of the appointment process, with one of the distinguished members of the collegium, airing out the views the way he has into the public domain.
Okay. Sanjay, is this a continuation of his judgment in the NJIC case? And how do you look at this? If judges, in minority dissenting judgments have to come out like this in the open, what happens?
No, it's not entirely a continuation of his judgment alone. Even the majority said that there should be transparency in the collegium work. His dissent was in as much as he upheld the constitutional amendment. While the majority said no, they struck down the constitutional amendment and went back to the collegium system. The question of transparency was foremost in the minds of all judges. Even the concurring judges, including Justice Kurian Joseph and Justice Madan Lokur, said that we should have a more transparency that has to be worked out in the memorandum of procedure. So even as the memorandum of procedure was being worked out, here is a collegium judge who says no, it can't be business as usual. What has happened earlier cannot continue. Even before we go to a new procedure, we must ensure that what happens hereafter should be totally transparent.
Do you think that it should have waited for the memorandum of procedure to be finalized?
I am not privy to all the workings, or nor is anyone except the collegium members privy to all that has happened within the collegium. He may well be correctly of the view that if we are to set a precedent hereafter, that precedent should be open and transparent. But while I accept that there should be transparency, there are drawbacks also. And one of the drawbacks is this. Okay, if there is transparency and somebody gets elevated further to the Supreme Court, fine. But what
What happens?
happens if one of the judges in the collegium or two of the judges have something against one of the candidates being considered, and they are forced to put it down in writing? Now, that will probably even render that judge not able to continue in his present position as Chief Justice of a High Court. Well, I am of the view that even if minutes are kept, there should be some procedure where these minutes do not become public knowledge immediately, but they are there for history's sake, where they can be looked up after a suitable period of time, some 5 years or 10 years down the line. That kind of limited transparency, where people are forced to record their reasons, but those reasons do not end up having unwarranted consequences.
That's an interesting point you made, Satya. So, what forced the judge to do this? What do you think forced the judge to do this?
Well, it's a question of conviction. Once he has taken a stand that there should be transparency.
He
in
has
the
waited
system.
for quite some time.
One. And second, there is, as Mr. Hegde pointed out, that there is even the majority verdict said that there should be transparency. Nobody stops anybody from lighting a lamp before the sun rises if it's night. So he has decided to do that, and it's always in favor of transparency. And raising an issue of transparency in a non-transparent manner, that he should be done in a very discreet manner and raised at the forum, he's done the right thing. People should know, and once he has raised the issue, it adds to the public debate. We are discussing it, and this is how institutional reforms are done. It cannot be left to the institution itself, because we have seen it for the last more than 23 years. It has not happened. It is not happening despite a constitution bench verdict to this effect, and hence it's good that somebody from within the institution has raised the concern, and then maybe this will lead to some sort of change within the institution, because people out there, they will realize that we need to change because things have changed and times have changed.
Maybe that is the key point. Justice Khan, the concern raised by both Dr. Rajkumar and Sanjay Hegde about Sanjay Hegde's is that there needs to be limited transparency because the consequences of that, and Dr. Rajkumar's point that whether this will actually strengthen the institution. Mr. Justice Khan? I think we have lost him. We'll go back to him. The same point, the same question to you, Prashant.
Yeah. No, I don't think that that the fears being expressed by Sanjay are really valid fears, because actually this whole issue of transparency in the functioning of the, at that time there was no collegium. At that time the appointments used to be made by the government in consultation with the Chief Justice, both the Chief Justice of the Supreme Court and the Chief Justice of the High Court, etc. This issue of transparency, that is making publicly known the correspondence and the views of the different functionaries about the selection and appointment of particular judges or transfer of particular judges, was discussed in great detail in S.P. Gupta's case by the then 7-judge bench, and they very, very clearly and categorically held that there is no reason why such correspondence or such views of the different functionaries, today it's the collegium, why this should not be made publicly known, because they said that all the arguments made against that, that is that it will inhibit people from frankly expressing their views, that was held to be not a valid argument.
Or
They
affect
said,
the person.
nobody
sorry to intervene, Prashant. Or affect the person concerned if he is not appointed, and then there are remarks against him. And he may be, as Sanjay was pointing out, he may be the Chief Justice of the High Court, and he may still have some term left for him. What happens in such cases?
No, nothing will happen in such cases. You see, unless there are some really solid reasons given by somebody, if somebody points out that this man is corrupt and this is the evidence of his corruption, and that becomes publicly known, then certainly that will cripple that Chief Justice, and he should be crippled. You see, there is always no harm in the truth becoming known. If somebody has made some irresponsible comments without any evidence, then that should be dismissed as irresponsible without
But
any
it can
evidence,
do it can do
etc.
damage.
If somebody has made some responsible comments, pardon?
It can do damage. If there is some unsubstantiated statements made and it goes on record,
It should.
it can do a lot of damage.
No, unsubstantiated statements will not do damage because people can always point out. Other members of the collegium should point out that there is no substantiation for this. This is just a unverified, unsubstantiated remark made by somebody. And the judge himself can point out that, look, there is no evidence of this. Therefore, why should this remark be taken seriously?
Okay.
So, maybe the opinion of somebody, that opinion can always be disagreed with.
Okay. Justice Khan? Justice Khan, you there?
Yes, I am there.
Okay. Justice Khan, the question which I was asking earlier when you got disconnected was that, do you think that this what is happening, the issues raised by Justice Chalameshwar in a public manner is going to help in strengthening the institution? There are doubts about it.
It will certainly. Girish, if you recall, we have been debating this issue for the last few years.
Yes.
And all along we have been talking about this transparency, fairness in the collegium functioning. And Justice Chancellor is on record to have said in his judgment, for example, there is no accountability, records are beyond the reach of any person. He has referred to Justice Romapal's remarks that trade-offs are taking place, that there is a lobbying going on, that there is a psychophancy going on, that there is an accommodation between the executive and the judicial branches going on. Now, if that is the kind of the functioning which a collegium is doing for an appointment to the higher judiciary, now God save this motherland. Now we have been talking from rooftops that please, for God's sake, bring some kind of an improvement in this functioning. And ultimately, when our debates led to the Judicial Appointments Act and the Constitutional Amendment, 99th Amendment, which was struck down by the Supreme Court, all along I have been pleading that Supreme Court gave a balanced judgment by quashing the Constitutional Amendment and at the same time by asking for the preparation of a memorandum of procedure.
No, that is sir, sorry to intervene.
How come this memorandum of procedure is not being prepared all the while?
No, sir, sorry, sir. Sir, sorry to intervene. Sorry to intervene. Do you think that Justice Chalameshwar could have waited for the memorandum of procedure to be finalized before going public?
No, it has been frustrating wait. In fact, our wait is frustrating also. Now, what are you doing? You are doing, in fact, the same thing which you were doing earlier, and all the exercise of having a National Judicial Commission Act and all the exercise of the Supreme Court telling you prepare a new memorandum of procedure and provide for the criteria and provide for the fairness in this and provide from some method, all that is going waste. Now, if all that frustration accumulates, what do you expect Justice Chancellor to do when in his judgment he has pointed out all those shortcomings which are there in the collegium working?
Okay. Okay, sir.
How could he, now, suppose, Girish, if he had gone to let me tell you the practical part of it.
Right.
Suppose he had gone into this meeting and three of the judges by majority would have said, no, we are not in favor of what you are saying. What could he do? He could do nothing. So therefore, he has stood by his judgment and he has lent support to the whole debate again of transparency and accountability and fairness being ensured in the process of appointment in the higher judiciary.
Okay. Okay, sir. Sanjay, now that he says that he will not attend these meetings, there are huge number of vacancies, there have to be appointments, memorandum of procedure has not been finalized, but still appointments have to be made, and if he doesn't attend the meetings, he says that you send it by circulation, which means that his demand will have to be accepted whether they like it or not, because they have to put it down on paper to send it to him.
Well, there are ways of eliciting the opinion of a member who wants it in writing. And you must also, why are we concentrating only on Justice Chalameshwar? You must remember that the Chief Justice of India has also said that we will work this out. So, these are people we have to treat as high constitutional authorities acting in good faith as they see the law.
Right.
So, it may well be that the other members of the collegium can come to a decision on certain candidates and say and request for Justice Chalameshwar's view on that.
How?
So, in writing, saying that X, Y, and Z we propose to bring to the Supreme Court. When none of us have any objections. Do you have any objections, brother? That could be one way, and that would reflect in the files. So there could well be some kind of halfway house till the ultimate memorandum of procedure comes about.
No, he very curiously in his letter, Justice Chalmeshwar says that, it has been the practice to go through the collegium files in his chambers and in his chambers earlier also, which means what?
No, well, what I get from hearsay evidence here, and that it's often these collegium meetings as to the entire structure of the meeting seems to be only with the Chief Justice of the day. The other members come in, then these proposals are put, and a general sense of the House seems to be taken. It may be that collegium members, unless they specifically ask for one candidate's files or the other candidate's files, if there are no objections, things are taken to be done. It may well be that Justice Chalameshwar wants a more institutionalized procedure where all the files are circulated to everyone and everything is as transparent as possible.
And minutes of the meeting is kept and things like that. Dr. Rajkumar?
Well, I think I don't think anybody in this panel, or for that matter the judge, part of the collegium, are in any way doubting the need for transparency. It was also recognized in the majority judgment that there are number of challenges in the existing mechanism for appointing judges, and we need to recognize that the need for seeking and ensuring transparency, there is consensus.
No, 1 second. Do you think that the way that this whole memorandum of procedure has, proceeded in the last several months, that there has been no sort of both the government and the Supreme Court have not been able to come to any.
Well,
you think that has resulted in this kind of a situation?
Well, as somebody who teaches constitutional law, I feel very awkward that after a judgment on a question of raising constitutional questions, a judgment of the Supreme Court is a determinative judgment. And after that, the process of consultation with the government in formulating a memorandum of procedures itself is very awkward. Then on top of it, we are all surmising what could be the reason why the MOP is, delayed. Well, there could be any number of reasons, including an obvious reason where potentially some of the provisions of the MOP, which is in many ways, inimical to the very idea of the judgment, is under negotiation. And that's where there is every reason for the judiciary to be, resisting the MOP itself. We don't know. All I'm trying to say is that it's this whole post-judgment, what is happening is just not the way we would expect a judicial matter to come to some determinative conclusion.
And at the highest level.
Absolutely.
Satya, Justice Chalmeshwar has a very interesting, in his letter, he points out that one way, in one of the interviews, he has said that one way of dealing with this is probably have interviews with the judges and with the aspirants. You think that is something which is not there in the memorandum of procedure as far as we know so far?
Which is not there, and but memorandum of procedure, as of now, nobody knows what has been proposed by the government and what has been rejected by except two things, that the government proposed that public interest and national security should be grounds for rejection, which the collegium has rightly rejected. But this debate, it is not about nitty-gritties. This is about the larger issue of transparency in the functioning of the collegium system. The collegium system, the Supreme Court revived. The government has accepted it. On record, the government senior ministers, they made a statement that we accept it. Thereafter, the issue of framing the memorandum procedure, to and fro it has been going on. There are certain basic issues on which both the government and judiciary can come together, and on those issues cannot be any compromise. And some of the issues that have been raised by Justice Chalameswar is, one is like there should be an agenda for the meeting should be circulated among these are the basic things. And why somebody is being selected, why somebody is being rejected, certain basic things, as Mr. Bhushan pointed out, that the name should be put out in the public. What is so secret about that somebody is going to be elevated? Because in the past we have faced situations where somebody facing certain allegations and corruption charges or criminal cases, they have been elevated as judges, and thereafter there have been impeachment proceedings.
Exactly.
So why not avoid such a situation? If you make transparency will act as a deterrent to too many things, and many people who think that they can become judges under this non-transparent system. And some people have said that meetings are not secret, they are clandestine. There are serious allegations against the system. It's better that the system reforms itself rather than to leave it to
Prashant?
TV debates where people raise so many questions about the
Prashant,
system.
Prashant, so you think that this will lead to some positive development, some positive way of appointments? Is this also going to influence the kind of memorandum of procedure which has to be drawn up now? How do you expect this to move from now?
Well, I don't think that the court should have left the memorandum of procedure in the hands of the government after having held that the collegium has primacy in the matter and that the government should not be meddling with the appointment of judges. I don't think they should have left the drafting of the memorandum of procedure to the government, because the government is using this memorandum of procedure to try and get a veto on appointments, which is to my mind not a good thing at all. However, I think this whole debate underlines the need for a full-time body for judicial appointments, not the regional judicial appointments commission which the government had proposed, which was an ex officio body of judges and law minister and a couple of jurists, etc., but rather a truly full-time 5-member, 7-member body which is completely independent of the government as well as of the judiciary, and which is able to devote its entire time to this whole business of selecting judges by first drawing up a criteria for selecting judges, thereafter drawing up a sort of eligibility list of candidates, measuring the candidates on the basis of that criteria, thereafter putting out the short list of the selected people on a public website so as to invite public comments, etc., and thereafter doing its final selection. This whole business of collegium or some ex officio body of judges plus law minister, etc., none of these in my view are the correct way of going about selecting judges.
Okay, Prashant, I think on that note we need to end that. This has raised another huge debate in this country, and hopefully it will lead to some positive developments, as Prashant is pointing out, as my other panelists are pointing out, that it should lead to more transparency is the underlining factor. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time.